Krista Holder-Williams, and I represent the appellant William Ferguson in this matter. This arises out of an automobile accident in Shelby County, Tennessee. Mr. Ferguson was struck by someone who was an off-duty Tennessee Highway Patrol officer who was also working for the University of Memphis. It is our understanding at the time as an employee. As a result of the accident and his injuries, we filed a claim with the Claims Commission, and that claim was denied. And so Mr. Ferguson appealed that claim, and his appeal was dismissed as untimely. And the basis of our appeal today is that the statute relied upon for the dismissal of that claim does not have clear definitions of the word filed or denial notice, and is ambiguous, and most importantly is imbalanced and unfair in the reading that it was given so far as this claim is concerned. So in the statute that gives them time, them being the Claims Commission, to review and send out their notice, they say that they will make every effort to honor or deny the claim within a certain period of time. But the statute that relates to us filing our appeal just says you have 90 days. It doesn't say make every effort. It doesn't say how to file it. It doesn't give a definition of filed. It doesn't give a definition of a denial notice. And in this particular instance, what happened is we mailed and have proof and have submitted within the record proof that it was mailed on the 90th day. And it was mailed contemporaneously with another appeal. They were stamp filed on 2 different days, despite being mailed on the exact same day at the exact same time. And aside from that,
is there an explanation in the record as to why they have different dates?
No.
Okay.
Not to my understanding, other than that the clerk, reading into it, it was my understanding the clerk just processed 2 things, arrived at the same time at 2 different times.
But there's no proof in the record that they were received in the commission's office on the same date, is there? I know
No.
you say you mailed them on the same date, but that doesn't necessarily mean that they arrive on the same date, does it?
No, Your Honor, it
Okay.
doesn't, no. Again, that was just my assumption since they went at exactly the same date at exactly the same time. So basically, what we are asserting is that this is a 1984 statute. Email was not contemplated at the time. E-filing was not contemplated at the time. And they are relying on the fact, partially relying on the fact that they emailed a notice to me on behalf of the claimant. However, that email did not include the language it was supposed to include to be effective. But they're saying regardless of whether or not they emailed it, that it is not the date of receipt of their notice, it is the date on their notice that is effective. Well, the envelope, or I'm sorry, a piece of paper that was wrapped around it had a date from Corvell Corporation, basically intimated to me that they mailed it a day after the date that was on the notice. So they have a date on it. They have the date that was on the piece of paper from Corvell that I would assume is what means they actually mailed it the next day, or it was processed the next day. And then there's the actual date that it was received by me. So essentially, under these circumstances, what we are saying is you've got a 1984 statute that is ambiguous and is very lopsided as to the effect to my client. They're basically saying, we'll make every effort to deny your claim, but you get this to us regardless of when we mail it, regardless of when you receive it. You get this to us within 90 days, filed in the clerk's office, at the mercy of the post office, at the mercy of the clerk's office, within 90 days, despite the fact that we've given ourselves allowances to make every effort. But there's a drop dead, as far as you're concerned, that it needs to be here, it needs to be stamp filed. And
When did you actually receive notice? When is
The
it
6th.
agreed that you received
the
notice
6th.
of?
I'm sorry, Your Honor, I think it was November. Yes, November of 2023.
November 6, 2023, and the 90-day period would have run when?
January the 31st, I believe.
Okay. Thank you.
So I don't think to the best of my knowledge, I could not find a case directly on point. I found cases where people might have submitted things much, much later, not within a few days, or an arguable brief period of time near the deadline that they were asserting. And I just, again, I think my most important point is that it's excusable neglect that does not prejudice them at all to get this 2 or 3 days later than what it was, especially with email and them getting the luxury of saying, I'm sending it by email, us not having that luxury of email or e-filing in this particular case, but them taking that luxury. And I just think that, again, with essentially the ambiguity of a 1984 statute not written when we contemplated email and e-filing, and the prejudice to my client, which is obviously monumental compared to the prejudice to them for getting something a day or two later, that essentially, in this particular case, under these set of circumstances, that it would do an injustice to my client to have his claim dismissed on this basis.
I'm going to ask you something. I'm hearkening back quite a bit. It's been quite some time since I handled a claims commission case, but I did long ago in my time in practice. And I recall then there being a mechanism to contact a commissioner or the claims commission regarding an extension. Is that something that's still something that is available to you?
I actually don't know, Your Honor, for the fact that I thought I was getting it in on time, and that the piece of paper that came to me said, you can mail this, you've got 90 days, and that's what I was trying to do. So I didn't actually look into the extension. I thought I was getting it in on time, so I didn't research that.
Okay, thank you.
You could have actually mailed this earlier, couldn't you? Didn't your client sign the notice in early December?
He did, Your Honor, but at the time, I was trying to also assemble documents and things to go along with it. I could have mailed it earlier, but it was not complete earlier.
When you say not complete,
I hadn't compiled the entirety of it, put it together.
but all you needed to do was send the notice that you were appealing that decision.
If I recall, there were additional things submitted with that notice.
Was that required?
I thought so, Your Honor, yes. If I'm recalling correct, I'm not certain. As I recall, it wasn't just a matter of, here's a piece of paper that says we're appealing. It included additional documents and things after he signed. And at the time, much like Judge Smith, who hasn't looked at claims commission claims for a long time, I have never really, unless I'm lying and I've done it before in my practice and don't recall it, appealed anything to the claims commission. So I had the individual whose vehicle it was and this individual, and I was trying to file them at the same time, and I was waiting for him. And I did not have to wait on him to file this one, no. I'm just saying I don't think my client should be prejudiced by me having mailed it on that date instead of them having received it in the clerk's office, stamped, filed on that date, especially not if they're gonna give themselves the latitude to make every effort to honor or deny something, and also give themselves the latitude to claim the date of the denial despite when I receive it.
But you don't find anything in the statute that extends the time for filing your notice beyond the 90 days?
No, Your Honor, not that particular statute, no.
Okay.
Anything else?
No, just rebuttal time. Thank you, Your Honor.
Thank you. We'll hear from opposing counsel.
Good morning. May it please the court. My name is Liliana Fairweather, and I represent the state of Tennessee in this matter. This court should uphold the trial court's decision because claimant's notice of appeal was simply not filed within the 90 days required by Section 98402C. Claimant did not file his appeal within the 90 days as required under the statute. The language is clear that claimant has a, quote, right to file a claim with the Claims Commission within 90 days of the date of the denial notice. And otherwise his claim must be dismissed. The statute unequivocally states that it is by the date of the denial notice, and this is not vague nor ambiguous. The Division of Claims and Risk Management emailed a denial notice dated November 2nd, 2023 to claimant's counsel on November 2nd, 2023, and from calculating from that date, claimant had until January 31st, 2024 to file his notice of appeal. But the appeal was not filed until February 5th, 2024, and so it was untimely filed. This court, in its opinion, this court in Howard v. State held that the standard is 90 days from the date of the denial notice, and that's the standard that the Claims Commission applied, and that decision should be upheld. Additionally, claimant's notice of appeal was untimely filed because the appeal period does not begin upon receipt of the denial notice. There is no case law that supports that the calculated date should begin upon receipt of the denial notice. Claimant's counsel did rely on Huron v. State, which was a workers' compensation claim that was appealed, but in their brief, some of the language was a little misleading in terms of the full opinion of the court was to deny, or was to uphold the dismissal because claimants didn't file within 90 days there. And they did calculate that date by the denial notice date.
Have you found anything that indicates whether the filing is jurisdictional?
The filing is jurisdictional because complying with all of these procedural requirements in 98402 subsection C is required before proceeding the Claims Commission.
Is it jurisdictional? Because I believe Judge Armstrong asked if, or perhaps it was Judge Smith, if you could obtain an extension for filing.
As I understand it, that it's a condition precedent to recovery. They had no choice. It was jurisdictional, and it must have been.
Let's look at a different example then. Filing with the Court of Appeals within 30 days is jurisdictional. Filing with the Court of Criminal Appeals is not jurisdictional. How do we know which is which? Now, I'm cheating because I just looked at Rule 4 of the appellate rules, and it says that filing with the Court of Criminal Appeals is not jurisdictional. We do know that filing with the Court of Appeals is, because you don't file your notice of appeal within 30 days, there's nothing we can do about it. You may have a great excuse, but there's nothing we can do about it. I'm trying to figure out what the distinction is here. The rules of civil procedure that I assume are applicable to the Claims Commission to some degree provide that in some instances you can extend time.
It's my understanding that Rule 602 for an extension in the rules of civil procedure is not applicable in the Claims Commission, and that an extension couldn't have been granted under those grounds. I'd have to do further briefing for this court if you'd like to be able to give you a full answer.
I'm just following the argument here.
Yeah, I understand.
So, how do we know if it's jurisdictional or not in this instance? I know, we know here because the rule says there's a distinction. Do we assume it's jurisdictional?
I believe, yes, we should assume that it's jurisdictional for purposes of this. The statute's pretty clear that following every one of those requirements is necessary before recovery, and so it'll have to be jurisdictional, one of those principles.
I know I've asked you about stuff you're not prepared for, so go ahead with your argument.
In addition, claimant's appeal should be considered untimely because the notice of appeal has to be filed, not just mailed within 90 days of the denial notice. The statute is also clear on it must be filed. And
Define filing?
the statute doesn't define filing, but the rules of civil procedure do. And under Rule 502, it needs to be given to a court clerk. Or sorry, not under Rule 506, I apologize. The filing of pleadings and other papers with the court as required by these rules shall be made by filing them with the clerk of the court. And in the Claims Commission, that is by mailing them to her for an initial notice of appeal.
Well, didn't she mail them on the date?
She mailed them on the date, but she has to receive them by that date.
Where does it say received?
It is also common practice that we typically do calculate it in the trial
But,
courts.
I mean, does the rule that you just quoted me say filed and received, or just, or mailed? I'm sorry.
In this one, it does say be made by filing them, which I understand, but then in Fanning v. Fly, which was a case from the 1800s, filing was required receipt by a court clerk, and so the case law clarified that point as well.
But did I misunderstand what you just stated earlier, that filing means by mailing, right?
Filing means, I might have misspoken, and I apologize if so. Filing is when the court clerk receives it. In this case, the court receives the filings by mail. So the date that she receives those mailed documents, that is the date of the filing, not
Not the date of,
that they're mailed out to her.
so the mailbox rule would not apply.
No, I don't believe so, Your Honor. Additionally, I don't believe the mailbox rule applies here, and if I'm correct in the rule, that would also require that the notice requiring action would also have to be served by mail, and in this case, it was served by email. There was a complimentary hard copy sent to her, to claimant's counsel's mailing address, but email's sufficient. Under the amendments to the rules of civil procedure, mail and email are both considered appropriate means of service.
I'm sorry, say that again, the last part of what you said.
Sorry. Rule 5.02 says that a document transmitted by email shall be treated as a document that's mailed for purposes of computing time, and they are considered equivalent in terms of serving the documents.
So she could have emailed her notice of appeal?
She couldn't have emailed her notice of appeal because she was required to follow service of a document is not the same as filing of a document, and so she needed to follow the filing rules, which required receipt by the court clerk, but did not necessarily, but Corvell, the entity that issued the denial notice on behalf of the Division of Claims and Risk Management, they were permitted to serve by mail because it didn't have to be a filed document. And I'd also like to address the excusable neglect piece. The state of Tennessee expressly waived its sovereign immunity by creating this statute, and while I'm sensitive to the occasions where claims are not able to be brought in the Claims Commission, that doesn't give them the right to pursue every single claim. And the excusable neglect was not requested in the trial court, relief due to excusable neglect was not requested in the trial court, nor was it shown or proven how this would have qualified as excusable neglect. And at the end of the day, there are necessary procedural rules for all parties to follow, including filing timely appeals, whether that is into the Claims Commission or into any other court system. And so in keeping with that, claimant should have also timely filed their notice of appeal to the Claims Commission. And I'd also like to go back and address the different mail dates. In the record, there was a attached receipt showing that two documents were sent via mail to the Claims Commission. And if you look at that document, I believe it's page 292 in the record, it will show that there were two different delivery dates. So those items were always expected to be delivered at different times. One was scheduled to be delivered on a Friday versus one was scheduled to be delivered on a Saturday, which could not have been filed until the following Monday, which would have resulted in a different period of time. And again, the standard is 90 days from the date of the denial notice, and that's the standard that the Claims Commission applied in this decision. And I would request that this court uphold that decision because the claimant did not file his notice of appeal within those 90 days as required. If there are no further questions.
Let me ask you, is there any proof in the record that the commission received the notice appealing within the 90 days, but didn't stamp it until days later?
There's nothing in the record that would reflect that. The notices of appeal have the file stamp date from when the clerk's office received them, but they only have the date of when it was filed, I suppose. So I guess we do not have a received date versus a filed date. But they do have a file date, and they use the same filing procedures for this case as they do with other others.
And in this case, is the file date the same as the received date?
I'm not
You said there
certain.
was some sort of stamp when they're received. So my question, is that date the same as the filing date in the commission in this case?
It's unclear to me when the clerk's office received the document. It was expected on Saturday, but I can't verify if it was received or not on Saturday. I can only verify from the notice of appeal that it was filed on Monday, February 5th, 2024.
I guess I don't understand. You said it was expected on Saturday?
There was a USPS shipping receipt with tracking numbers, and it provided on the receipt estimated delivery dates. And so for one document, it had an estimated delivery date of Friday, and she's referred to a companion case that was received that Friday. And then there was a second item on the list that had a estimated delivery date of Saturday, February 3rd, 2024, and that would have fallen on a Saturday when the court's office would have been closed, and so it was file stamped the following Monday once the clerk's office was reopened. If that distinction makes sense.
So if it had been file stamped on Saturday, would it have been timely?
It was due January 31st, so it was still a bit untimely.
When was the 31st?
Thursday,
Oh, okay,
so
all right.
it wouldn't have been file stamped in time either way. By mailing it on the day that it was due, it was extraordinarily unlikely that it could have gotten to the court clerk's office in time to be filed. If there are no further questions, the state would respectfully request that this court uphold the Claims Commission decision because claimant did not file his notice of appeal within 90 days. Thank you for your time.
Thank you. We'll hear your rebuttal.
Yes, Your Honor, I think it will be brief. It's just basically a recap that the statute is ambiguous. We're going back to the 1800s to define filing, apparently. And aside from that, we're not enlarging the implications of anything here today, just balancing the ambiguity of the statute and the unfairness of the result in this particular situation, because the statute itself is from 1984 and doesn't contemplate all of the measures we have today to both file things electronically and communicate letters. And again, they might have sent a letter on the 2nd, but that's not what was on the outside, basically giving the date of when it was sent. I did not get an email on the 2nd, and the email I did get did not have the requisite language to make that a notice. So it was the 6th. And we would say, since they don't define either filing or the receipt of the denial notice or the issuance of the denial notice or the process for the denial notice, they don't define denial notice or filing, that is the 6th that we should have relied upon. And it was filed timely, and that it was excusable that it did not fall within some clear-cut, bright line, we can send this when we want, regardless of when you get it, and you are beholden to 90 days to get it through the mail process and through our filing process. Because even with the explanation that these two things were received on 2 different days, they were stamp filed even further apart than the dates that they were not received. We don't know when they were received, but predicted to be received. The dates that they were predicted to be received were still several days apart. They were only a day apart from each other, I'm sorry, but when they were stamped was several days apart from each other. So we're at the mercy of a lot of different things to get in that 90 days without a definition in this particular case, except going back to some case law that's not directly on point and old law giving us definitions for some of these things that could have been clarified.
But you're aware that under the statute, the 90 days there's no mention of the 90 days starting to run from the date of receival of the denial. It says it starts to run from the date of the denial, and that you have 90 days in which to file your appeal. Nor is there anything in the rule that says you get extra days if you attempt to serve it by mail, is there?
No, but what I received was a big block letter thing that said, mail this here, with the address, without anything else that said you can email it, there's any kind of extension, or you can, and also I just assumed that the date of the denial would be the date that it was received, and someone was on notice.
But the
not
statute doesn't say that.
It does not, Your Honor, no.
And you realize the statute is in derogation of common law, sovereign immunity, and the only way you get a chance to file this claim is because the legislature enacted the statute to allow it.
I do understand that, Your Honor. I just don't think they're going to be prejudiced by 2 or 3 days when they've given themselves the latitude to get theirs in when basically they make every effort to do it. I just don't think the prejudice compared to the weight of what my client is going to suffer for defining and maybe making it the actual date that it was mailed, or giving you the option to e-file, or the option, or a definition for filing.
Thank you.
Thank you.
counsel. We appreciate your argument. We will review the record, and we'll attempt to get you an opinion at the earliest possible time. Thank you.
Thank you, Your Honor.
You may be excused. We're going to take a brief recess, Miss Angie. And if you'll get the next case ready to go.